It has been nearly a month since the federal conviction of Mexican drug lord El Chapo, and given the charges he was convicted of, you would think that Chapo's story would end right there. After all, Chapo was found guilty on 10 counts, all connected to running a drug cartel the prosecutors say earned him nearly $14 billion. And 2.5-month trial, it ended with jurors deliberating for more than 34 hours before convicting Chapo. He could be sentenced to life in prison. But Chapo's attorneys say those convictions were just the beginning of their defense. They're planning an appeal. Now, they are turning to an interview that one of the jurors gave to Vice News. It was proof, they say, of juror misconduct, which they hope will get the case reopened or dismissed. Now, in the interview, that juror, they claimed that many of his own colleagues on the jury were following the trial in the news and on social media in clear violation of the rules the jurors must face and the instructions that the judge repeatedly gave them on a daily basis. Another claim? At least 7 jurors and alternates knew of rape allegations against Chapo that were not included in the trial, and that some of the jurors were following the Twitter feeds of reporters who were covering the case. Now, to mount their appeal, El Chapo's team has brought on an expert at these kinds of claims, a man who is also a longtime friend of this program, Mark Furnish, a defense attorney who's also an adjunct professor at the Elizabeth Haub School of Law at Pace University, and he's also argued before the U.S. Supreme Court and has survived hours as a guest here on RFL. Mark, to speak to this, we've laid out the general facts here. You got 5 jurors allegedly and 2 alternates who didn't listen to the judge's instruction, and they more than surfed social media. They were following along, and they learned of alleged acts by the defendant El Chapo here, even though the judge told him not to do so, specifically alleged rapes of children, young girls. I'm imagining I know the answer before I even go there. You believe that crosses a threshold which would necessitate a retrial?
Well, Rich, we really have to explore the facts. The reports, of course, are very troubling on their face. Judges have a lot of leeway in terms of how to deal with this sort of thing, but the facts are very disturbing, and in our view, they're going to necessitate a thorough inquiry and an evidentiary hearing, and if they're substantiated, it would present a serious threat to Guzman's right to a fair trial. So we're going to press the judge to investigate vigorously.
Now let me put you back in law school when you're talking to your students. To necessitate here round 2 of this, as I understand it, it has to be both what the juries heard outside of the courtroom and the significance of it. Do you believe this in and of itself, unless more comes out at discovery, would be enough to necessitate a retrial? And I ask that because the mountains of evidence that were laid out for the jurors that had nothing to do with these young girls, and the defense was a grand total, I think, of 25 minutes that they put up for them at the end of the day, would arguably this really say, all right, you know what? We got to do this thing all over again here, that the crimes that were already presented at trial wouldn't have been enough to necessitate a conviction?
Well, that's not really the test, Rich. There are 2 different species of juror misconduct that you have to think about in analyzing these types of questions. One is what goes on in internal deliberations in the jury room, what they talk about, what they think about, how they discuss and analyze the case. The federal rules of evidence place that type of situation, that type of inquiry, off limits for a federal judge unless there's invidious racial discrimination or something like that. A much more searching standard applies, though, when there are allegations of prejudicial external information reaching the jurors and being discussed among the jury. That is wholly separate from the evidence that was produced against Guzman and calls into question the fitness of these jurors to serve and render a fair and impartial decision, wholly irrespective of the evidence that was presented against him.
Do you believe the number makes a difference, in that if this was one juror that was sampling his or her Twitter feed, in the lunch breaks, that's one thing. But if it's 5 full-time jurors as well as 2 alternates that were doing it and talking amongst each other, there's a distinction with a difference?
Yes, there is a distinction with a difference. It's going to be critical to determine not necessarily the numbers, but whether there was discussion among the jurors of Guzman's guilt or innocence before deliberations began, and whether those discussions touched on the external information that was reported in the press.
Now, people at home, Mark, are saying, wait a second. El Chapo, my God, you weighed, you didn't count the amount of evidence that they laid out against him, nothing to do with the alleged rapes of these girls. And moreover, come on. Probably most trials where they don't sequester the jurors, at least one of them or 2 of them or somebody are watching the news at night, talking to neighbors. We don't want them to. They're instructed to do otherwise. But the argument is, isn't that just a reality of what jurors, being humans, actually really do?
So it's not unusual for a juror, a disgruntled juror that's unhappy with the verdict, to seek out the defense lawyers and talk about things that may have happened during deliberations, jurors refusing to deliberate, et cetera, because often that smacks of sour grapes. This is a different situation where the juror in question apparently agreed with the verdict, yet independently sought out not defense lawyers, but a neutral lawyer to voice concerns about the process. So while the usual scenario may be viewed with some suspicion, because it's a disaffected juror who looks for a defense lawyer, this is not that at all. This is a horse of a different color. This is a juror who was satisfied with the verdict, though apparently had some scruples about sending Guzman away for life, who, on their own volition, came forward to not a partisan defense lawyer, but a neutral member of the press to say, hey, this process seems to have been tainted, it was unfair, it was infected, and we need to do something about it.
And you think, Mark, there might be more here, not just what we've learned about this particular correspondence? Are you guys looking that there might have been additional correspondence with these jurors about other subjects as well?
Look, we're not permitted to undertake a wholesale inquiry. We don't know who the jurors are. We're not permitted to approach them for interviews or to harass them or to pester them. So we're going based on what's been published so far. We're going to ask the court for an evidentiary hearing, and we're going to ask the court to conduct the investigation with our participation. So right now, we have the information that everybody else has, and the information is troubling on its face and warrants careful inquiry and meticulous scrutiny.
So I just want everyone to remember, when you look up Mark Furnish, and he is referred to within the legal community as the Mr. Sophisticated Defense Guy, just remember when he had veins popping out his head, when he was yelling at us at the table here. So Mr. Sophistication, I know the other side to Mark Furnish, but you're certainly in the wheelhouse, and that's obviously why they brought you on board here. We'll continue to follow this case very closely. Mark, as always, my friend, I appreciate it for you.
Thanks, Rich. Appreciate it. Thanks for having me.
Where's Mark?
Exactly. We joke, there is, as you were saying, there's a jury chaos theory and stuff. Well, they've got Captain Chaos to handle this. That's it. He's really good, not just because we're friends with the guy here, but this is really where his giant brain is best. Absolutely. But you think he's got a shot here, right, to get a retrial?
Look, these are very disturbing allegations, and the magnitude of them, the reach that they extended to, this is problematic. Judge Kogan, made very specific findings. The government sought to introduce just an enormous amount of other prejudicial evidence that wasn't charged. At one point, he said, this is not a murder case with some drug charges, it's a drug case, and you're not going to just present it as a murder case. I mean, they had so much other evidence. So, he was very mindful of limiting what the jury heard. And the allegations that these jurors allegedly heard about, considered, and talked about, and we're talking about half the jury, those are very, very disturbing allegations.
And you say this is not typical, but this is more a problem at the federal court level than it is others.
Well, remember, in federal court, the judge does much of the questioning of the jurors before the jurors pick, so the lawyers don't participate that much, and maybe they could have identified somebody that would be a problem in this jury, or several people that could be problems. But you know, Rich, this says a lot about one particular juror. You know, that juror had the opportunity during the course of that trial to bring this to the judge's attention, and he didn't do that. And now he's doing it after the fact. The inquiry really has to be about that juror first, because he's making allegations about other jurors that, quite frankly, are unfounded.
That's a great point, because the judge says to the jury after every day, report
Apparently
to me
multiple
if there's
times
a
a day.
problem.
I'm already over here real quickly. This does feel like, maybe not if I'm El Chapo, but a technicality. They literally pin hundreds, if not thousands, of murders on this guy here, and they convicted him of, you know, multiple life sentences in all likelihood. Is this delaying the inevitable here, really?
Well, you know, there's a tendency to always go and say, look, this is all the evidence we didn't hear about. There's a reason, though, that we call it a court of law. And the minute we stop adhering to the rules, we put every single one of us at harm's way.
All right. All right, when we come back here, a hard-to-grasp story when it comes to justice not served and a man's life ruined in the process. This guy spent 25 years in prison for murdering his wife, but it turns out he didn't do it. And he may have avoided prison altogether if his prosecutors had shared critical evidence with his defense team. Now, he's fighting to change the law, including in our neck of the woods, so nobody will have to go through what he did. It's a story you'll want to hear, and it's next on RFL.